Hello everyone, this is your host Urvashi Chauhan. Welcome to Courts Today by Live Law, your one-step destination to all legal developments in the country. Let us start. The Supreme Court has put a temporary restraint to the Interim Committee of Retired High Court Judges from overseeing or conducting elections for the Church of South India, that is CSI Synod. This committee was appointed by the Madras High Court to manage the elections and administration of the CSI. The Supreme Court's decision comes as a response to a suit filed against the High Court's appointment of the committee. The suit also seeks a request for new elections and a declaration that recent amendments to the CSI constitution are invalid. The initial lawsuit in this case sought to remove the moderator of the CSI, Dharamraj Rasalam, call for new elections, declare the CSI constitution amendments invalid, and appoint an interim administrator. The single judge of the High Court had found that the amendments were not properly processed and that Rasalam's election was flawed. But the single bench did not interfere with the election for other positions. The respondents in the case argued that there were significant issues with the electoral process, including the way the electoral college was formed. They believed that these flaws meant the entire election was invalid. The Madras High Court in April had appointed 2 retired judges to take over the administration of the Church of South India and conduct elections for the Synod. They were allowed to hire additional retired district judges to help them. However, this decision was challenged in the Supreme Court by Dharamraj Rasalam, the moderator of the CSI, and others. Now, the bench of Justices Bela Trivedi and Pankaj Mittal has issued notice on the special leave petitions challenging the High Court order. The bench clarified that the court was only limiting the committee from taking any administrative steps and was not setting aside the appointment of the administrator. The principal bench of the National Green Tribunal has taken suo motu cognizance of a newspaper report stating that India lost 2.33 million hectares of tree cover since the year 2000. According to the article, as per the Global Forest Watch, which tracks forest changes in near real time using satellite data and other sources, India lost 4,14,000 hectares of humid primary forest from 2002 to 2003, making up 18% of its total free cover loss in the same period. It also stated that between the year 2001 and 2022, an average of 51.0 million tons of carbon dioxide equivalent per year was released into the atmosphere as a result of tree cover loss in India. The tribunal opined that the matter indicates violation of the provisions of Forest Conservation Act, Air Prevention and Control of Pollution Act, and the Environment Protection Act of 1986. Taking suo motu cognizance, the NGT has sought response from the Central Pollution Control Board and the Union Ministry of Environment, Forest and Climate Change. It also directed the Director of Survey of India to submit a report showing the position of forest cover in India with specific reference to Northeast from the year 2000 onwards, with each 5-year interval covering the period up to March 2024. The matter is listed for 28th August for further consideration. The Madras High Court recently directed the railways to compensate the family of a man who was hit by a train while sitting on the railway platform and succumbed to injuries. In this case, the Railway Claims Tribunal had previously dismissed the family's claim, saying that the man recklessly crossed the track and sat on the platform edge, making it not an untoward incident or an accident. The family challenged this decision before the High Court. The family argued that the man was injured while waiting on the platform to board a train with a valid ticket and that the tribunal's decision was based on unsustainable suspicion from a divisional railway manager report. The railways argued that the injury was self-inflicted as the man was trespassing by crossing the track. Justice K. Rajshekhar noted that since the man was sitting on the platform, it was the railway's responsibility to prove that the incident was not an accident. If the man had been crossing the track, the railway's argument might have been valid. However, there was no evidence that he was sitting on the edge of the platform, so it could not be considered a self-inflicted injury. Due to the lack of evidences from the railways, the court ordered them to compensate the man's family. The Delhi High Court has held a man guilty of criminal contempt of court for posting a video on social media, defaming the judges and claiming that they were doing illegal acts. The man was a respondent in a case filed against him concerning a property in city's New Ashoknagar. The court noted that the video specifically defamed the judges and that the man alleged that he was disclosing the true face of the courts in front of Janta Ki Adalat. Also, it was argued before the court that the man willfully interfered in the judicial work, obstructed the administration of justice, scandalized and lowered the authority of the court. Even though the man said that his intention was neither to defame the court nor the judges and tendered unconditional apology, the court played the video and found that the man very evidently lowered the dignity of the court. A division bench of Justice Suresh Kumar Kaith and Justice Manoj Jain thus held him guilty under the Contempt of Courts Act 1971. The matter is listed on 19th July for sentencing. And lastly, the Allahabad High Court has criticized an investigating official for hastily filing a charge sheet under Section 306 of IPC after dropping the charge under Section 302, which was initially mentioned in the FIR. The court highlighted that the investigating officers in most cases discharge their duties perfunctorily as per their own whims without adhering to their assigned obligations. It also expressed concern over the disturbing trend of filing charge sheets indiscriminately, especially in cases of murder, without due diligence in evidence collection. The order was passed by the bench of Justice Manju Rani Chauhan while dealing with a bail petition filed by a person against whom a charge sheet was filed under Section 306 of IPC. Let me tell you where Section 306 deals with abetment to suicide. Section 302 of IPC defines punishment for murder. On the last day of the hearing in the matter, the court had asked the IO in this case to explain as to how he converted Section 302 to Section 306. Even though he could not justify his action in his personal affidavit filed before the court, he tendered an unconditional apology for the inconvenience. The court, expressing its disapproval, has directed the Commissioner of Police Agra to send the IO for special training to prepare him for investigating offences. Until completion of his training, he should not be entrusted with any investigation. With respect to the bail order in the matter, the court noted that the state could not show any exceptional circumstances for denial of bail to the accused, who has been accused of forcibly giving some poisonous substance to his wife, leading to her death. Therefore, the court granted him bail. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.